This is an essay sentencing case, so please go ahead and turn it off if that is a trigger because there are graphic explanations of what happened and you don't even want to, it's not worth taking the chance. This is kind of an interesting one because the judge does not accept the plea deal, and there's also the fact that he is not a US resident. So enjoy. Well, not really, because it's kind of yucky. So yeah, just watch it.
Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villamil.
And are you Mr. Villamil?
Yes.
Are you gonna have to speak up so I can hear?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Villamil, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
I wasn't able to find a count 3 in the docket, which only has abbreviated listings. These are the two counts that were listed. Both were filed on September 19th of 2022. The warrant was issued 9 days later. And then on 10/4, there were multiple listings looking like he was arraigned, and it says there were special bond conditions. The GPS tracking had to be modified because he was a truck driver. So obviously that didn't work. On 10/4, it looks like he went in front of the magistrate and a bond was set for $100,000. There's several other entries where they're going back and forth with discovery, pretrial, things like that. He made bond on 11/23/22, but then on 12/19/22, his pretrial supervision was terminated. It says UNSAT. And then there was a warrant issued and he was remanded without bail and has been in custody since 12/19/2022.
No, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your
Do you believe he's currently competent and was legally sane at the time of the offense?
Honor. Yes, Your
Mr. Villamil, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had a chance to confer with an immigration attorney?
I have conferred with an immigration attorney. I have informed him.
So all immigrants, whether they're in the country illegally or here with a green card, are subject to be deported if they violate the law. There's two main categories of crimes that subject them to deportation, and the first is crimes of moral turpitude, and the second is aggravated felonies. And these crimes aren't definitively defined in the US immigration laws. Aggravated felonies more than the moral turpitude crimes, but it's an interesting read. Aggravated felonies under the immigration law are considered heinous crimes such as murder, SA, or drug trafficking. So this crime would absolutely qualify, and there would be no question whether he would be deported following this crime, if convicted.
That a plea to this is he's actually a permanent resident. A plea to this would be a certain denial of future permanent residency and deportation after serving a prison sentence, which is what he's pleading to.
All right. Mr. Vial, did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of entering a plea in this case as it relates to your immigration status?
Yes, Your Honor.
All right. Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Sir.
According to the plea, you're pleading on count 3. Punishments to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this
Exactly.
complainant his relative or not?
Yes.
Okay.
Yes.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
I know we offer states exhibit number 1 and all attachments.
Okay.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will find you guilty. Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept
Your
this
Honor,
agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to re-traumatize the child by bringing her in and talking to her about this case yet.
this case is horrible.
I completely get this puts the judge in such a weird spot. So you don't want to re-traumatize the child, especially since she's a young child, but does that give him a lesser sentence? Why should he benefit from that? Frustrating situation. Anyways, trigger warning. graphic explanation coming up, and while it's not the normal type of assault, it's a very detailed explanation. So skip ahead if you don't want to hear it.
And I mean, I know he says he's pleading to a one-time, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal
Yeah.
issues with that. So,
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's, that's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's,
And you got turned on.
no, I didn't. I'm telling you, I'm not like physically like, well, I did get turned on, but not, well, after a while, she just kept doing that. Tell her not, you know what I mean? Like,
So you blaming a 6-year-old?
I'm not blaming my
Your
6-year-old.
Honor, if I may, my client was sexually abused when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously is not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will
So
have to
he's
live
being released after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has, what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that. To do that, we have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which
And what country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point. What were you thinking?
Yeah. I can just say sorry, but like the only thing I can tell you is that I didn't like, I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her, you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mhm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in and, as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up, and he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 75-85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you, and now that he has done it, and what
No, he pled no contest.
He pled no contest because I advised it, because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah, so I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried, I'm begging and telling you, please, I'm telling you, please. I'm not trying to forced my hand in her or in her. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't, I don't know how to explain.
No, so the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated
the
the
thing
anus.
is, I just don't know what she wants. Like, she spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole, like, at least 4 or 5 times. Dropping her pants, like, literally, like, it's not like I'm telling you, like, my actions were right.
I know, I'm just trying to figure out where you are mentally and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time, he told police officers that he had put his finger inside of her penis.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has sexual deviancy. And it's obvious, all of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right, so this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother, and the benefit of the child was to get this done, have no right to appeal, so the child could move on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right, if you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
All right.
Your Honor, 2 things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow.
And if I'm in jury trial
Oh, tell 13, you need to be here tomorrow.
and have her jury wait.
Yes. This is district court. So I'll see you all tomorrow.
This hearing took place on a Thursday. They ended up returning on Monday for the follow-up hearing.
All right. All right, court is calling 2023 CR 0543, State of Texas versus Wilbert Villarreal. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villanelle.
All right, we were here on July 6th for a plea. The court would not accept the plea. The court informed both parties that the court would accept a plea of 20 years. Defense?
Yes, Your Honor, we wanted to respectfully inform the court that our intent is to file a motion to disqualify the court from this proceeding. And that at this time, the court's offer of 20 years to the client is rejecting because we are waiting for that motion. We have tendered a check to the court reporter in order to get the record. And then once that record is received, we'll file the motion and we can go along.
The judge mentioned that this was a life felony. And I wasn't sure exactly what she meant, but I looked up the actual offenses that he's charged with, and the sentence is 5 to 99 years imprisonment. Minimum sentence was increased to 25 years if the victim is under 6 years old. And I thought that they mentioned that the child was 6. I'm not sure. So he turned down a 20-year sentence to go to a jury with 3 counts facing 5 to 99 years imprisonment. What do you think his odds are?
On that process.
All right, well, your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case. Your jury trial is set for August 8th. And whenever the court reporter is finished with the record, the reporter will be able to give that to you. I do know that there's a backlog, the records that she has from out of Houston and for the fourth court.
Yes, sir.
All right, is there anything else?
No.
All right, thank you. See you back on August 8th for a jury trial. Ms. Ferguson, can you give them a jury trial reset, please?
So he's seeking to have Judge Boyd removed from the case because she didn't accept the plea deal. To do that, he has to prove that the judge has a personal bias or prejudice concerning the subject matter of the party. That's kind of a hard one to prove because of the heinous nature of the subject matter. However, she did make that comment.
This case is horrible.
Yes.
What is wrong with you?
And that could be used against her, so it is possible. In this case, as it's running, his time to enter a plea bargain is run out and he's going to trial. If that keeps going, he won't be able to enter another plea bargain and he has to take his chances at trial. However, if it gets reset, I'm not sure if the chances for getting a plea bargain also get reset if it gets sent to another judge. I was not able to find that. I'm assuming that it does, but I'm not positive. So we'll see how it plays out.